Good morning, Ms. Platic.
Good morning, Your Honor. How are you today?
Doing well. You?
Not too bad.
Okay, we can go ahead whenever you're ready.
All right. We have before court Haley, is it Pontaine? Am I pronouncing it right? She is here after failing to appear for a show cause before the referee on January 8th of 2024. This is the first and only bench warrant for this matter with bond currently set at $500. She reports no new employment. Her last payment was made on September 29th of 2023 through income withholding. Friend of the court requests the next hearing be set for March 6th at 8 a.m. before Your Honor.
Ms. Fontaine, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 6th, 2024, 8 o'clock a.m. You will get notice of that. Are you able to post a bond, ma'am?
Like, do I have any money?
That's,
I don't
yeah.
I'm broke right
Yes, no, maybe?
now. No, I don't have any money. No.
Okay. Well, it is your first bench warrant, so the court's considering that, but you haven't paid in now about close to 6 months. What I'm gonna do is I'm gonna reduce your bond in hopes that you could be released. I'm gonna set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Can I just say that the only reason I wasn't paid was because I was pregnant and I lost my job and then I just had my baby? Because like I've been trying to get back up on my feet.
Okay, well, hopefully you're able to do so.
I just don't know if anybody's gonna be able to. So I can't get out today?
Nope, not unless you post a $200 bond. Okay, you're excused. Have a good day.
All right. And then we had one other matter for Brady West. He was also supposed to be arraigned on Friday for his FOC matter. He has again refused to come down for arraignment, is what the jail has told us.
Okay. Well, what the court will do is, obviously, the court recalls Mr. West refusing to appear the last time. What to do is the court will continue the bond at the current amount in this matter, as Mr. West has not appeared to state anything as it relates to a modification of bond or anything else. So the court will simply continue the bond previously set.
So, do we just try to arraign him again on Wednesday? Or would you like me to call the docket and we can set it for the hearing?
Yeah, let's set up for a hearing with an attorney and see if he will speak with the attorney
Okay,
next time. And then we can go from there at that
we'll
point.
set it for the 6th at 8 o'clock before you.
See if he's willing to talk to Mr. Sullivan or not.
All right. Thank you, Judge. That is
Court
all
will
we
note
have
the
this
appearance
morning.
of Mr. G on behalf of the plaintiff. This matter is before the court on the, I think I have defendant's motion to exclude child. Was that your motion, Mr. G?
Yes, yeah, there looks like an error. It's the plaintiff's
Okay.
motion.
I think they just had it switched around when they sent it to me then.
Yep.
Mr. G, in these matters, what we typically do is we do take testimony, but not on motion day. We take that on a Wednesday at 1:30. I don't know if you have a alleged father that's going to appear and give any testimony as well or acknowledge paternity in this matter. But I do have here, I had it here that based upon the dates, the court is going to require some DNA testing and a report because of the time frame based upon the pleadings as to when the child presumably conceived and born, that there is a possibility. So court wants to be certain that again that the plaintiff in this matter would be excluded if in fact he is not the father. So Mr. G, I'll leave it up to you to get that the DNA taken care of and having those reports done. Once you have the report, contact my office and we'll set it for an evidentiary hearing on a Wednesday. And then we can take some testimony at that time and enter the DNA test report as well. Anything else, Mr. G?
Yeah, I just had a quick question. There's another companion file. It's a support file concerning these same children. I don't know if we can do that today. If you could enter an order consolidating those cases. At one point, I read the register of actions there, and I read a note indicating that the court, that the front of the court was going to provide DNA testing services, but I don't believe that's happened in that case. I don't know if that would be these parties are fairly indigent, I guess there's been a fee waiver in this case, so I suppose my question is the front of the court available to handle the cost of the DNA testing in this matter?
Well, they probably would be. I don't want to say they are, but more likelihood they would, with the fact that they have a DS case proceeding. Well, I don't want to consolidate it at this particular point. But Mr. G, if you want, you can do an order for DNA testing in the DS case and state that the front of the court will handle that and say that they'll have it done within 30 days of today's date.
Okay, I will do that, Your Honor. Thank you.
Okay, you can submit that under 7-day notice and then we'll get it done. Okay.
You're now
Thank
paying
you.
To the best of your ability.
We'll conclude this matter. Everybody. Okay. Court will note the appearance of Ms. Henderson on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, exclusive use, and other relief.
Thank you. Good morning, Your Honor.
Good morning.
The parties in this case share two minor children, ages 15 and 11. Plaintiff has filed for divorce. However, the parties remain in the same home. Shortly before filing for divorce, defendant left the marital home for a period of time of approximately 2 months. And during that time, plaintiff provided full care and custody for the minor children. The minor children looked to the plaintiff for necessities of daily life, their guidance, affection, and anything that they need. Defendant in this case has anger issues. The parties were in some episodes of domestic violence previously to this filing. It is plaintiff's position that defendant needs to seek anger management counseling before he's able to meet the needs of minor children. Throughout the marriage, plaintiff has the history of providing all necessary care and custody for the children as well. We're asking that plaintiff be granted on a temporary basis full physical and legal custody of the minor children, and defendant be granted parenting time that does not conflict with their schooling and activities. We're asking that the overnight visits commence with defendant upon him having appropriate sleeping arrangements for the minor children, as prior to filing, he spent time, about 2 months, with his mother. We're asking that the child support be granted in accordance with the Michigan Child Support Formula. Upon plaintiff's information and belief, defendant is currently employed at Franklin Plastics. It is unknown how much he earns. However, he has a history of earning at least $18 an hour. Plaintiff is currently employed at II Stanley, earning approximately $846 weekly. The children have Medicaid for health insurance, and there are no daycare expenses. As it relates to the exclusive use of the marital home. Upon the finalization of divorce, plaintiff wishes to keep the marital home. There is currently no mortgage on it. Defendant has a history of long periods of unemployment, during which and currently plaintiff has been and continues to pay all of the house-related expenses. Plaintiff is willing to continue doing so if she is granted exclusive use of the marital home. The main reasons for asking for exclusive use of the home are persistent anger issues in defendant and abusive behavior towards plaintiff, as well as the fact that defendant left the marital home for a period of 2 months in late 2023 prior to filing, where he stayed with his sister without returning to the marital home. Shortly before the filing, defendant returned to the marital home and continued his abusive behavior towards plaintiff. To plaintiff's knowledge and belief, defendant is able to reside with his sister like he did before the filing when he left the marital home. And for that reason, Plaintiff is asking to be granted exclusive use of the marital home, which she could continue occupy with the minor children, and prohibit defendant from entering the home without explicit permission of plaintiff. And the final issue we're bringing up to court's attention today is a request for a mutual preliminary injunction to preserve marital assets. The parties here to have significant savings in different bank accounts.
That's part.
Upon learning that plaintiff was filing for divorce on or
Go, go.
about,
Go,
on or
go.
about February 1, 2024, defendant went to the bank and closed the joint account of the parties, taking sole possession of $59,000 and telling plaintiff she has no access or right to that money. Plaintiff is requesting that defendant be ordered to put the funds in an escrow account pending settlement. And further, plaintiff is requesting the court to grant a mutual preliminary injunction ordering that neither party shall take, dispose, pledge, damage any of the marital assets during the pendency of the divorce. Thank you. For that reason, Your Honor, to summarize, we're asking that plaintiff be granted sole physical custody of the minor children during the pendency of the divorce, that defendant be granted parenting time with the minor children that would not interfere with their schooling activities and that would provide them with sleeping arrangements appropriate for the minor children when they're with dad. We're asking that child support be ordered in accordance with the Michigan child support formula based on the current incomes of the parties. We're asking that the parties be granted joint legal custody of the minor children. We're asking that plaintiff be granted exclusive use of the marital home and be responsible for all expenses associated with the marital home. We're asking that the court order defendant to put the funds withdrawn from the joint bank account that he closed in an escrow account pending settlement of the parties, and for a mutual preliminary injunction against pledging, damaging, or wasting marital property. Thank you, Your Honor.
Gracias.
Thank you. Mr. Valdivia, what's your response to the motion?
To begin with, good morning. There are things that are not like she says
La casa y lo que tenemos,
about custody, the house and what we own, about the children and the money. The money is in an account in the bank. The only thing I want to clear out is that I took a little bit of money to pay the monthly fee of my son's school, to pay the house taxes, and to fix a car.
sí.
Well, let's address the issue of custody first, sir. What's your response?
Historia.
I want joint custody.
Well, address the issue of she's asked for exclusive use of the house. Are you opposed to that?
We talk about if the house needed to be divided or be sold so that we got equal parts. She said that if she was going to keep the house, she will give me half of the value of the house. And I agree for everything to be divided in half so that my children have another home to go when they are with me.
Sir, is it correct that you had removed the $59,000 from the joint account?
I changed accounts. The money is there, except for the money that I took, continuing for the expenses of my school or my son's schooling, the taxes. I want to also mention, when we bought a new car for her, we agreed that I will have the same amount of money to buy a car for me. My son, my children are witnesses, and she agrees to this or agreed to this.
When did you buy the car for her, sir?
Around October.
Okay. Anything else you'd like to tell me, sir?
If you will be able to ask me things by parts so that I would be able to answer one thing after the other.
Okay, I'm just asking if you have anything else than what you've stated.
No, we agreed that everything would be by half.
Todo, la custodia, la casa, todo lo que tenemos que sea por mitad.
The custody, the house, everything we have by half. And I agree with the divorce and everything, but as we agreed.
Porque si yo también quiero tener la custodia de mis hijos conmigo, que compartamos mitad y mitad la custodia.
I also want to have joint custody.
Your Honor, may I provide a brief response?
No, I don't. This has went on long enough. I don't need a response. Well, I will tell everyone that the court is not going to divide everything up on today's date. Many, if not all of these issues will be decided later. Court is only going to address issues on a temporary basis today. The court will start by awarding to the parties joint legal custody. Court will grant plaintiff temporary physical custody. Court will grant to defendant standard parenting time. Court will order support consistent with the incomes of the parties. Court will grant to the plaintiff exclusive use of the marital home, defendant to vacate the home within 21 days of today's date. Plaintiff shall be responsible for all the expenses of the home from this date forward. Court will order that the defendant turn over to Attorney Henderson the balance of the $59,000 within 7 days of today's date. And Ms. Henderson shall maintain that in an interest-bearing escrow account. And the defendant shall provide the receipts for the expenses that he paid out of that amount of money. And we will divide up the balance of that at some point as the case proceeds. Court will grant a preliminary injunction against either party disposing of marital assets. Ms. Henderson, we'll ask that you would prepare that order and submit under 7-day notice of entry.
Una pregunta,
Anything
una
else,
pregunta
Ms.
que
Henderson?
tengo.
Yes,
Anything
Your
else,
Honor.
Ms.?
Effective date of the child support order today?
Yes, today's.
Your Honor, so will my client be responsible for the expenses also 21 days out?
No, I have her effective today's date because she's going to get that. We'll address all those at some later point.
And then, Your Honor, I just need to verify Mr. Valdivia's income. What is his hourly rate?
$17.
$17.
40 hours a
No.
week?
¿Cuántas horas a la semana?
40.
40 hours a
Thank
week.
you.
Una pregunta que tengo.
I have a question.
Okay, in a
As
minute.
I'm paying the bills of the house, does she have to pay this month's bills?
Give me that again. I'm sorry.
As I'm paying the bills of the house in this moment, now she has to pay those bills from now on?
She will have to pay the expenses from this date forward. And then as the case proceeds, we'll decide, is the house going to be sold or is she going to buy you out? We'll take care of that at a later date.
It's okay. May I ask him a question, Your Honor?
Yes.
Señor Valdivia, ¿usted entendió que el dinero que tiene en esa cuenta tiene que sacar toda la cuenta y darle el dinero a la abogada Henderson? Mr. Valdivia, did you understand that you have to take the money out of the account and give that check to Ms. Henderson? Do you understand that you have to take the money out of the account and give that check to Ms. Henderson?
Sí, está bien, yo lo saco y se lo doy a ella.
Very well. I will take it out and give it to her.
Okay.
Okay.
That will be the order of the court and we conclude today. Everyone's excused. Have a good day.
Thank you, Your
Eso
Honor.
es todo.
Una pregunta que tengo.
I have another question.
Okay, hurry up. I want to get this
Okay.
concluded.
Eso que
Do
se
I
te
need
tiene
a
que dar.
lawyer? Does these proceedings continue? I'm a little bit confused.
It's always best to have a lawyer, but it's up to you as to what you choose to do.
Señor,
A ver, para que yo entienda así, esté claro.
so that I understand. Continúe.
Okay, thank you. You're
Muchas gracias.
excused. Have a good day.
Que tengan buen día. Lo siento, señor Valdivia.
Thank you to the interpreter.
Pero, perdón,
You're welcome.
oiga,
Sí, señor Valdivia.
lo que yo no entiendo es que va a seguir más cortes.
Van a haber más cortes. Señor Valdivia, esto es un proceso. Este es el principio del proceso.
Ujú.
Y van a haber varias cortes hasta que el divorcio se finaliza y cada parte obtenga lo que tiene que obtener. This is a process and there will be different sessions and then each party will get whatever the party gets. ¿Entiende eso?
Sí lo entiendo, pero lo que quiero estar claro es que si necesito el abogado o ya está clara la situación.
Siempre es bueno tener un abogado.
Ok.
Es su decisión.
No, sí está bien, entonces para yo así.
It's good to have a lawyer, but it's your decision. Okay.
Sí, gracias.
Thank
De
you. Court will note the
You're
appearance
welcome.
of Ms.
Have a nice
Henderson
day,
on
everybody.
behalf of the
Thank you.
plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and other relief. Ms. Henderson.
Good morning. Thank you, Your Honor. It's my understanding that the parties have an agreement regarding the child-related issues. At least they have been separated for approximately 2 years. During the separation, they've exercised week on, week off parenting time with a minor child who is 16 years old. And it's appropriate for the joint legal custody and joint physical custody with equal or close to equal parenting time to continue during the pendency of the divorce. The parties agree that in the interim period, there's no child support that shall be payable to either party.
Okay, Ms. Henderson, is there any public assistance involved?
There is no public assistance involved in this case, Your Honor.
Okay.
Thank you.
The court would, again, maintain the status quo with the parties paying the bills that they are currently paying, unless at some point, if there is public assistance, then the court would not allow a waiver of support.
I understand that, Your Honor. Thank you. Regarding the other two issues that we're bringing up to court's attention, we're asking for the status quo to continue regarding payment of marital bills. Again, the parties have been separated for 2 years, but continue to pay marital bills as they were paid during their cohabitation. Specifically, defendant in this matter paid for the family cell phone plan of 4 lines, medical and dental insurance, car insurance for 4 vehicles, and plaintiff's car loan payment from his disability income. Plaintiff is currently employed at the ARC of Calhoun County, earning approximately $900 per week gross. Defendant is employed at Lakeview Ford, earning commission on top of $400 gross per week. He also receives VA disability in the amount of approximately $4,100 per month. Due to the disparity in incomes with the car loan being paid in lieu of child support, we're asking for that status quo to continue. However, Your Honor, there has been one caveat. This weekend, my client found out that the joint USAA account from which the bills were paid was actually unilaterally closed by defendant, and my client has no way of knowing what funds were taken out of that account. She is asking for defendant to provide accounting and also to continue the status quo regarding bills as they have been paid. She wants to make sure that the bills are in fact being paid. The next issue we're bringing up for court's attention is the sale of a marital home. The parties purchased during the marriage, and during the marriage, they both occupied the home. However, after the separation, defendant continued to occupy the home. His name is the only name on the deed. He put the house up for sale. It's currently pending an accepted offer. We're simply asking that when the sale finalizes, that the proceeds from the sale be put in an escrow account for equal or other equitable division between the parties until the resolution of the case is reached. So to summarize, we're asking for—
I don't need a summary, Ms.
Okay.
Henderson.
Thank
I've
you.
heard everything.
Thank you.
Mr. Wolf,
that's all.
what's your response?
I'm sorry.
Is that to me?
Mr. Wolf?
Yes, sir. So pretty much everything that she was stating was factual, minus some of the debt has occurred since separation, and I would prefer not to keep continuing to pay for debt that was occurred during separation. All the other debt and bills that need to be paid are still going to continue to be paid because they have to be. Total bills that have been paid monthly total $41.51, which is more than my disability income. So I'm actually paying out of my own pocket as well. So I would like the car and insurance and phone that are occurred after separation be paid by the plaintiff.
Okay. Those were bills that, in fact, were occurred prior to separation, though, weren't they, sir?
Not the phone or the vehicle and insurance for the vehicle that was purchased after separation.
But you were paying for that before separation.
No, sir. I was paying for a different vehicle that was on lease. That lease got turned in. She purchased a new vehicle. Then that has been on my bill list as well.
Okay. What's your response to that, Ms. Henderson?
Your Honor, essentially, the parties have been separated for 2 years. The defendant in this case continued to pay for the vehicle, whether it was on lease or whether it's a loan. Because the parties are agreeing to no child support, which would be appropriate based on the disparity in incomes, we're asking for defendant to continue paying the car loan in lieu of child support. It's not a very high payment to my understanding. And we would ask for that to continue during the pendency of the divorce, as well as cell phone and insurance being maintained under the joint plans as they have been.
Well, what the court will do is the court will order that the defendant would pay the vehicle payment to the extent that it did not exceed what the prior lease was. So if she bought another vehicle and let's say it's $100 more, she'll be responsible for that. He'll only be responsible for what the prior expense was. Likewise, the insurance, if the insurance is more than what it was on the lease vehicle, he'll only be required to pay what he paid at that time on the lease vehicle. Sir, on the issues of joint legal and joint physical custody, are you agreeable to that?
Yes, sir. It's been the same for a little over 2 years now. I'm okay with continuing.
And my understanding was that you were alternating weeks. Is that correct?
Yes, sir.
Court will order that continue as well. The court will order that, sir, that when the house sells and closes, that those funds would be placed in an interest-bearing escrow account that would not be, again, able to be accessed except by court order, so that those funds remain there subject to division in the later divorce proceedings. Anything else, Ms. Henderson?
Your Honor, regarding the cell phone plan and also medical dental insurance.
I said that those would continue.
Those will continue as previously ordered. Okay, thank you.
Mr. Wolf, anything else?
Yes, sir. During the inhabitation of the home, I have gone through reconditioning of the home that was agreed upon that 50% was going to be covered at time of closing, to where equity would be divided and those bills be paid. So far, bills have totaled over $4,900 in reconditioning, with more bills to continue. And I would just wish that those would be paid equally at time of closing of home.
Okay. Ms. Henderson, do you have any problem with that?
No, Your Honor, so long as the other bills continue, we would not be opposed to that amount be taken off the top. It's my understanding it's approximately $4,962 at this time. I don't anticipate any other bills coming forward as the house is already pending. So
Okay.
I'm not sure what other bills are
Okay.
coming.
Mr. Wolf, the court would order is simply that you would provide copies of the bills to Ms. Henderson, and that would be whatever the current ones are of $4,900 and any additional bills as well. And the court would then order that those would be paid out of the house proceeds first. They'd be paid to the defendant to reimburse him, and then the balance of the net proceeds would be divided equally.
Yes, sir. There will be further bills coming because inspection had turned up multiple issues that need to be addressed before I can sell the home.
Okay, well, provide those as you have those, provide them to Ms. Henderson.
Yes, sir.
Okay, Ms. Henderson, I'll ask that you would prepare the order, submit under 7-day notice of entry.
Thank you, Your Honor. Just to clarify, at first you said that the proceeds to be placed in an interest-bearing escrow account, but then you stated that the proceeds after reimbursement of defendant are to be split equally. So which one?
Well, yeah, no, I don't need it in, because it sounds like the parties have already worked out how they're gonna do that with the, again, reimbursement to the defendant of his cost of maintenance and repair of the house. And they've agreed that they would divide that equally, so the court won't order that it be placed in escrow.
Okay, thank you.
Okay, thank you. Court will conclude this matter. You're free to go. Have a good day.
Thank you.
Thanks, sir.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Mr. Zubek on behalf of the defendant. This matter is before the court on the defendant's motion to show cause. Mr. Zubek.
Good morning and thank you, Your Honor. The motion to show cause stems from the order that was entered, and specifically the provision regarding the child support deviation and the party's intent to deviate the child support to zero once the minor child was placed on the defendant's insurance at work and that the Medicaid case was closed. Now, the work insurance has been applied to the minor child. Now, in the plaintiff's answer, she mentions that it's against Michigan law to deviate child support to zero if there is public benefit being received. And regardless of that, the reason that we asked to show cause was Another thing she mentioned was that there was no timeline put in place. Now, usually if there's an order of judgment and there's a house being sold or some sort of property disposition, there's usually a timeline that's put in place. Now, the reason that we decided against that for the order was we simply didn't want some sort of adverse effect on the minor child, and we're looking out for the best interest of the child. But if the plaintiff continues to refuse to make any sort of effort to close the Medicaid case, you know, we just need to know kind of what the status on that is, and, you know, where do we go from there?
Okay. Ms. Reed, how soon, I note that your client has contacted the state and has taken the child off Medicaid, but they haven't closed the case. How quickly can we get that closed?
The child is still on Medicaid, Your Honor. The plain language of the order says once the Medicaid case is closed, the child still qualifies for Medicaid benefits. This child has extraordinary medical needs. She has epilepsy, and the parties can't afford to have her removed off of Medicaid. They can't afford to pay the deductible. They can't afford to pay the uninsured medical expenses. This child sees a lot of neurologists and specialists and counselors due to her medical and mental health needs. And so my client is abiding by the order because the Medicaid case has not closed. She has not been removed.
Okay, well, why wasn't this brought up when we had the original hearing? You mentioned nothing about the fact that the child couldn't be removed.
Which original hearing?
The hearing when the court ordered that they would deviate when the child was removed, was never brought up the fact that the child couldn't be removed.
We did not have an order from the court regarding this. This was an agreement reached at mediation, and then we entered the order by stipulation of the parties, and I do believe we're disputing what exactly means when the Medicaid case is closed. It's my understanding that the defendant's position is that this agreement means that my client was supposed to remove the child from Medicaid, and our position is that that's not what this order says, is that when the Medicaid case is closed and the parties are able to deviate under Michigan law, then they'll go down to zero. But right now, she's not ordered to remove her from the Medicaid case.
Okay. Mr. Zubik, what's your response?
I mean, it absolutely is ordered. I mean, even if it was on mediation, it was entered through an order, so that makes it an order. I mean, she wants to mention the plain language of it. I'll mention the plain language says it's the intention of the parties that child support will deviate to zero once the Medicaid case is closed. Again, we didn't want to put a timeline on that as to not to adversely affect the minor child, but obviously there has to be some sort of something put in place where it seems like they have no intention, that they obviously have no incentive to try to close any Medicaid case, and that only further adversely affects Mr. Moss.
Okay, Ms. Reed, again, getting back to it, when do you anticipate that they would be able to close that Medicaid case? Because obviously that was the intention, is that we deviate to zero once it was closed. Now you're saying, well, it can't be closed. So why did you agree they would deviate to zero when it could be closed?
We agreed that it would deviate once it was closed, not that my client would go and close it. It doesn't say plaintiff shall contact DHHS and close the case. It was my understanding, my client's understanding, that it would be deviating when the parties could actually deviate. When the Medicaid case was closed, there were no longer public benefits. The flip side of this is after we reached this agreement, Mr. Moss contacted my client saying he wasn't going to be paying uninsured medical expenses, which would put this child's life at risk.
Well, as you know, again, the orders for support do require that someone pay, that they divide up the uninsured health care. And I don't care what he says about not doing it. If he's ordered to do it, he'll do it.
The issue with that provision, that would require FOC enforcement. And between the time that we're trying to get FOC to enforce those uninsured medical expenses, for be it medications or healthcare expenses through the specialists, Michaeliana could be dropped from services due to non-payment.
Well, you can always file a motion and get that before the court, and we could take immediate action as well. Anything else, Mr. Zubik?
Yes, Your Honor, just quickly, I wanted to also just put on the record in the defendant's, the plaintiff's answer to our motion, she mentions that it was a frivolous motion. She requested attorney's fees. I'd just like to state that I believe it's not a frivolous motion, and certainly that attorney fees should not be granted.
I'm not going to grant attorney fees. Obviously, there's a lot of issues involved in this matter and trying to get it resolved. And there's no, again, no clear violation in this particular matter. It appears that the parties just have some other issues that have arisen in trying to get the child off of Medicaid.
May I speak, Your Honor?
No, you
right.
have attorneys. The attorneys will speak for you. Ms. Reed, anything else?
No, Your Honor.
So what do we do with regard to the Medicaid? How are we going to get that closed such that the insurance can, again, kick in and that we might be able to, again, deviate in this matter?
It's my understanding that Medicaid is currently acting as secondary insurance and that his insurance is covering it. My client, or covering part of it, my client would have to contact DHHS to see what she can do.
Okay. Well, what I'll do is a court will order that the plaintiff would contact DHHS within 30 days, find out what she can do, keep Mr. Zubik informed of what that is. The court can reserve on the issue of, again, any support or deviation, and the court can, again, make up for that in the future once we know clearly what's going to happen with regard to the Medicaid. Mr. Zubik, I ask that you would prepare an order consistent with what the court's ruled and submit that under 7-day notice of entry.
Will do, Your Honor. Thank you.
Thank you.
Thank you.
Trouble PLLC? Can you hear me? We cannot hear you. We cannot hear you. All right, so maybe here under someone else. So let's bring Jason Taylor in and see. Please unmute, user.
No, that is definitely not my client.
Yes, let's see who Jason Taylor is. Okay, Jason Taylor.
So
Yes, good morning.
Good morning. Are you here for which hearing?
Yes, we represent Kinsale Insurance Company. We're actually a non-party, but one of the entities identified in the motion.
Which motion? Which case, please?
Oh, excuse me. It's the motion to compel turnover of insurance proceeds.
Good morning. This is Lynn Breimer from Strobel.
All right.
Can you hear me now?
I can. I'm gonna put
Perfect.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. McKenzie on behalf of the defendant. This matter is before the court on the defendant's objection to temporary custody parenting time support order submitted by Ms. McNiff. I did read the pleadings. It seems that Ms. McKenzie has objected in that stating the court had not entered or not ordered legal custody, but simply had said the temporary custody. Well, Ms. McKenzie, what I do in these is if I don't differentiate and I simply award custody, I'm awarding custody of both for legal custody and physical custody unless I differentiate. Does that take care of your objection?
Your Honor, I think she just messaged and said that she can't unmute herself.
Oh my goodness, it's been a Monday.
Well, what the courts will do is, because I do have a lot of other cases still going, is hopefully Ms. McKenzie can hear me and could note that how I addressed her objection. If in fact that's insufficient, I guess she can renotice it at a time that she can join and can unmute herself.
I think we also have her objection on child support today.
We do. Okay, that's.
So, I mean, should we just go to another, let you go to another motion and let her figure it out and we'll.
Why don't we do that and then we'll come back.
I'm gonna remove her so she can.
She can rejoin. Ms. McNiff, Ms. McKenzie must not want to talk to you or me today. I don't know which one. I'll blame it on you.
She's been emailing me, but.
Oh, okay.
So I think it's you.
Probably is.
And this. All right.
Court again will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. McKenzie on behalf of defendant. The matter is before the court on the defendant's objection to temporary order for custody parenting time support. Previously entered in this particular, or submitted in this matter. Ms. McKenzie, did you hear when I stated their issue concerning the legal custody?
Yes, thank you. Thank you, Your Honor, I did. And I apologize to all the parties and the court, of course, for.
No, that's fine.
Issues. Yes, I did. And
you had some, you had some additional objection on support. Is that correct?
I do. Thank you, Your Honor.
Go ahead.
And that is dated February 12th. So plaintiff father's verified statement at box 20 indicates that he had a weekly gross income of $2,000. And if you use that that is a verified representation under penalty of perjury. So I believe that that is the appropriate figure to abide by. And it was at the end of the year. So it looked like December 28th, 2023, his verified statement was signed, and his representation to the court under penalty of perjury was at $2,000 gross weekly gross per week. So using $8,000 as his gross weekly as his gross weekly, and about 81.83 for my client based on her first pay stub of 2024. Her year to date was 81.83. The child support should be in the neighborhood of 327. And I will advise the court that I have just put this figure together, and Ms. McNiff does not have this figure, but she and I have spoken a few times, and she recognizes that our position was and remains that we are entitled to rely on the plaintiff's verified statement under penalty of perjury as to his income. And the response that was filed by the plaintiff to our objection saying, whoops, he really didn't know what his income was for the year, that simply is inaccurate, and I don't think that it's appropriate to rely on that. It was the end of the year, and he certainly would have known for the last 52 or even 51 weeks what he was getting in his pocket every week. So I'm asking the court instead to enter an order that I will submit to Ms. McNiff, and I'll either notice it for entry or send it under 7-day, whichever the court prefers.
Okay.
In addition, I'll just say this quickly. I did take a look at his 2022 tax return, which Ms. McNiff did furnish me a few days after submitting her order, and so we do have that. However, I had a CPA go over that, and there is a questionable deduction of $5,037, $5,049 in Social Security tax. So I sent, anyway, I had a CPA review it, and he does not think that everything was done correctly, at least on the 2022. So I'm asking the court to rely on the verified statement under penalty of perjury. The representation was $8,000, $2,000 per week, and enter an order consistent with the plaintiff having $2,000 weekly gross. Thank you, Your Honor.
Okay, Ms. McNiff, why can't we rely upon the verified statement?
Your Honor, my client is self-employed, and while people who have W-2s certainly have some idea of what they made at the end of the year, my client has no idea. As many of us who are self-employed have no idea until after they deduct expenses and account for all of the various expenses that they would have during the year. I provided Ms. McKenzie with the 2022 tax return. My client just recently finished up his 2023 return, and his 2023 return is pretty consistent with 2022. I believe 2023 is going to come in about $5,000 less than 22, mainly because he has less depreciation. So I took his income from his tax return in 2022. I added back in the depreciation in order to come up with a figure that was just over 50,000. I believe 23 will be about 45,000. Why Mr. Fields thought that he was making more than that, I'm not sure. However, the tax returns are what they are. He doesn't prepare them himself. He has a tax preparer. One of the issues in his income is in the past when the parties were residing together, Ms. Bird held a contractor's license. She took the test and she had the construction license. When the parties separated, my client was no longer able to work under her license. And so his income has significantly decreased over the last 2 years as the result of having to find other people who would allow him to work under those licenses. Maybe at one point he was making closer to $100,000 a year, but I would ask that the court allow me to use his income tax return as an appropriate indication of what his income is. I can use 22, I can use 23, I can average the two, whatever the court directs me to do.
Okay. Anything else, Ms. McKenzie?
No, thank you, Your Honor.
Okay. Well, what the court will do is the court will, at this point, order that you can utilize the 2022 and the 23 and average those, and that will set the support on that basis. But I will say that's subject to further modification based upon further hearing where we might, you know, Ms. McKenzie can address the issues that she said as it relates to some errors on his tax return, et cetera. I don't know if they'll find those errors carried through on the 23, but again, we'll be subject to further modification after hearing in this matter. So Ms. McNeff, you can change that issue on the support, resubmit that under 7-day, and allow Ms. McKenzie, you to do an order that would again state will utilize the average of those two, subject to further modification after hearing in this matter.
Very well. Thank you, Your
Okay.
Honor.
I'm a little confused, Your Honor. You're asking me to do the order?
Well, the order that not Ms. McNeff will do the order. Well, why don't I, as long as she's doing the order, why don't we just put the provision that is subject to that's how we're going to figure it based on the average of the 2022 and 2023, and that any support modification after further hearing will be again retroactive to the effective date.
I can do that, Your Honor.
Okay. Okay, thank you.
And the commencement date should be the date of our last
hearing.
Okay.
Your Honor, the only other thing I'd like to do is to preserve my legal issue regarding the verified statement having been signed under penalty of perjury.
Well, again, the court would preserve that, but obviously recognizing that, again, if people are incorrect or there's an error, I'm not going to let a mistake, again, trump, if you would, or take precedent over the actual facts if we have later hearings. So you can
As long as I get to bring that to the court's attention.
you can
Thank
bring
Your
that
Honor.
up. You can bring that up at that time, and we'll have to ask. We'll have to ask the plaintiff in this matter why, you know, what was the reason for the error, how he made it, et cetera. That'll come up at a later hearing.
127 CB A1 Asphalt versus Bolero Lanes. Attorney Miller Wilson is filling in for Attorney Battenberg, and Thomas Hitch for defendant.
Good afternoon to both of you.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Time and place for the settlement status conference in this matter. Ms. Muller-Wilson, tell me what's happened.
Your Honor, first and foremost, Mr. Battenberg has retired, so I will be the attorney on this case.
Mr. Battenberg retired?
He sure did, the 31st of January.
Oh, man.
After a long career with our office, and so well deserved, but we do miss him.
Well, I'll tell you, he and I, we were clerking for firms in Grand Rapids when we were in law school. So I started at the same time he did. So you should tell him he can't retire till I can retire.
I will tell him.
Yeah, if you see him, tell him that I was complaining the fact that he shouldn't be retiring yet.
He will be in the office tomorrow, so I will tell him.
Okay, great. Maybe he'll change his mind then, huh?
That's right. I'll tell him he needs to come back on this case so the two of you can still commiserate together about the fact that you're still working. But
okay.
The status of this case is such that Mr. Hitch and I have been communicating regularly, and we are in the process of picking a mediator. Both of us have made suggestions. Both of us are investigating those mediators. Mr. Hitch would like until Friday to answer the complaint. The deadline is Wednesday. I don't think that is unreasonable at all. And Mr. Hitch has also talked about filing a counter complaint, but we'll discuss that later because I've talked to my client. So I think we're on a roll to move forward under the usual court process. We do, of course, both have to do our initial disclosures and the like now that Mr. Hitch is on the case.
Okay. Just keep our office informed of when you do have the mediator picked, because what happens if you don't do it here shortly, then our mediation clerk will assign a mediator, and I don't think you want that. So
no. Mr. Hitch, did I miss anything from our conversation this afternoon?
I'm sorry, Ms. Wilson.
Did I miss anything from our conversation?
No, not at all. The only thing I would indicate is that we do have disclosures of expert witnesses. And if the court would indulge us, we would like an additional 15 days. I was brought on the case not too quickly, but I anticipate naming an expert sooner than that. But just as an accommodation to the parties, I would appreciate that.
Ms. Muller-Wilson, is that a problem with an additional 15 days?
Not at all.
Okay. then I will ask you, Mr. Hitch, just to do an order to that effect and
I
submit
will
it.
do that. Thank you, Your Honor.
That way we have something to file, because I, quite frankly, I'll tell you, I won't remember that,
No,
a
that's
month or
fine.
two from
I'm
now.
more than
so-
happy to do that, Your Honor.
Okay. Okay, thank you. Do that, and then keep us apprised of what's happening with mediation, and I think that's all we need to do at this point.
If I could just take a second, Mr. Hitch, are you available right now for me to call you?
After this phone call? After this hearing? Yes, I surely am.
Okay,
I have something coming up at 2:00, but before then I'm free. Thank you.
okay, very good, thank you.
Okay, thank you both, and have a good afternoon.
Nice,
Good luck.
nice
Thank
being
you,
before
Your
you, Your Honor. I don't think I've had the pleasure before, but thank you very much.
Okay, well, thank you for saying so.
Should we set another status or just, okay, all right, thank you.
Okay.
Let's continue.
Have a good afternoon, everybody.
Yes.
Bye.
I'll talk to Mr. Hitch.
2 p.m. Attorney Greenlee
We'll
Core
just-
for
we'll just go with the
defendant.
next. Okay. Good afternoon to both of you. Ms. Warner, you're not familiar maybe with a case scheduling conference, and what happens in these cases, what we attempt to do is put in place various timeframes and processes so that the case proceeds in an orderly fashion. So what I'll do is I'll ask you various questions first, and then go to Ms. Greenlee Clore to again get her response as well. So I don't know what you've been doing as far as has there been communication or what's been happening at this point. But Ms. Warner, maybe you could enlighten me. What issues do you believe to be in dispute in the case?
I guess at this point, I'm under the impression that we're fairly in agreement on things, unless there's something I don't know. We've created a pretty good routine with our kids that I believe we're both happy with. I assume we'll split our assets 50-50, and that's what I'm under the impression of. We've had good day-to-day communication, but maybe not final communication regarding the assets.
Okay. Ms. Greenlee Clore, what's your thoughts on this?
Just update Ms. Warner. Just because I'm saying these are contested doesn't mean that we don't have an agreement. We just have to list them as contested for today. But right as of today, Your Honor, we have parenting time, custody, support, and property contested, and I believe mediation is appropriate.
Okay. Ms. Warner, as she stated, what that means is that they're putting them down as potential issues because you haven't resolved them as of yet, but
Sure.
But anticipating that, that you should be able to do that.
Yes.
So I will list all of those issues. Are you in need of discovery? Ms. Warner, discovery is the process whereby you acquire information from the other side. Are you anticipating discovery?
To the best of my knowledge, no. Neither of us have a great deal of things to separate between the two of us. I think it's very simple as far as that goes.
Okay. Ms. Greenlee Clore, what's your thoughts?
The only thing I can think of is that I do not have a financial form from Ms. Warner, so I do need to receive that.
Why don't I put, we'll give it about 30 days, but we'll put April 1 as the date. Ma'am, you're going to have to do a financial disclosure.
Okay.
By court rule. So that's something that you're going to have to prepare, okay?
Okay.
We will then send the matter to mediation in April. That's whereby you would meet with an attorney mediator, and he would attempt to resolve issues in the event that you have not been able to do so amongst yourself at this point.
Okay.
Ms. Clore, who would you like as a mediator?
I would propose Attorney Michelle Woznicki.
Ms. Warner, do you have any problem with Ms. Woznicki serving as a mediator?
I guess I'm not familiar, but I don't have a specific mediator in mind. So no.
Okay, we'll put her down, and then we'll see what happens. Do you have an alternate, Ms. Greenlee Clore?
I guess alternate would be Attorney Colleen Marcoux.
Okay. We'll set the matter for a settlement conference on May 13. 2024 at 1:30 PM. Parties are required to be present unless we've come to a full resolution prior to that time.
Okay.
Is that in person or via Zoom, Your Honor?
Excuse me?
Is that
Zoom.
in Zoom? Okay. And then Ms. Warner, you're going to get an email from Attorney Woznicki's office to schedule that, okay?
Okay.
Anything else, Ms. Warner?
I do not believe so.
I will tell you, just because we're setting all of this up doesn't mean you have to go to mediation. If you can get it resolved prior to that time, then you'll be able to save yourself some money.
Yeah, that'd be great.
The mediator does charge for their time.
Absolutely. Absolutely.
Okay. Well, if you can send, and this time you can send various proposals to Ms. Green LeClore. You can go back and forth, whatever you need to do if you want to get resolution, okay?
Okay.
Okay, well, we'll let you go then, and we will send this order out. I will say to you, Ms. Warner, make sure you pay attention to the times and the dates in the order, because there are some things that have to be disclosed and things that have to be filed, and if you don't comply with those orders, it could have ramifications in your case later down the line, okay?
Okay.
Okay. Thank you. You're free to go. Have a good day.
Thank you too.
Okay. Good afternoon to both of you. Mr. Mirthu, on this matter, just to let you know, a scheduling conference is whereby we set in place various processes and dates so that the case will proceed in an orderly fashion. So what we're going to do is I'm going to be asking Ms. Sachs some questions first because she represents the plaintiff. Then I'll go to you and get your input as well. So at this point, Ms. Sachs, what issues do you believe to be in dispute in the case?
Your Honor, the only remaining issues are property, debts, and child support.
Okay. Mr. Mirthu, is that your understanding?
As far as I know, it was property and debts. From what I remember of the paperwork, it said that nobody was seeking, or Miss Raines wasn't seeking child support, but yes, I understand.
Yep. Okay. Well, she has a right to, and again, I don't know if there's public assistance, but if there's public assistance involved, then she has to.
There is, Your Honor.
Okay. You cannot proceed without a support order when there's public assistance involved. Ms. Sachs, are you in need of discovery in this matter?
I would ask for 60 days of discovery, Your Honor.
Okay. Sir, what the discovery is a process whereby you can acquire information from the other side. So should you need any information from Ms. Raines, you have a right to do that, but you'll have to do it before May 1, okay?
Okay, May 1st.
May 1st, correct.
Okay, and I can still go through, I'm sorry if I can't remember the name. Is that Miss Sachs, the attorney, not through Miss Raines herself?
Yes, you can go. If there's a problem with communication, then you'll want to go through Ms. Sachs, correct?
Okay, thank you.
Ms. Sachs will send the matter to mediation in May. Who would you like to mediate the case?
Attorney Brundage, Your Honor.
Sir, do you have any problem with Mr. Brundage serving as mediator?
I have no personal knowledge of who this is.
Okay. Well, just let you know, Mr. Brundage handles about 80 to 85% of all the mediations in the county. So obviously he has a good grasp of things and a good understanding of what's happens in these cases, et cetera. So
okay.
Who would you like as an alternate in the event Mr. Brundage is not able to serve?
No preference, Your Honor.
Okay. Mr. Marthio, is there anyone you have as an alternate that you would suggest?
Not at this time.
Okay. I'll just leave it blank, and then if necessary, then we'll have to come back and set another individual at that point. Court will set June 3rd as the settlement conference date. Parties are required to be present unless come to a full agreement prior to that time. With that, Ms. Sachs, is there anything else you have or any questions?
No, Your Honor.
Mr. Mirthu, is there anything that you have, any questions?
Not at this time, no.
Okay. what happens is, they will be contacting, Mr. Brundage to set that up. And then he will, probably communicate with you or at least send you some paperwork on the mediation process. I will tell you there is a cost associated with that because you have to pay him for his time. And, so with that, we'll just proceed and you'll get the scheduling order in about, a few days. Mr. Matthew, understand that there are various times set forth in the scheduling order that you have to disclose various things. I'm letting you know because oftentimes if somebody is in pro per, they don't pay attention to that. And then it comes time for trial where they try to introduce exhibits or call witnesses and they haven't disclosed those, they wouldn't be able to do so. So make sure that you pay attention to the timeframes that are in that order so that you don't, you're not prejudiced in the future, okay?
Okay, sounds good.
Okay. Thank you both, and we'll get this sent out to you, and you have a wonderful day.
Yes, you too.
Thank you.
Please unmute, Mr. Boucher. Can you hear us? You're still muted. Try it again.
You're still muted.
Can you hear us now?
Yes, it was
Okay.
saying that they'll allow on mute.
It's
Well, you're on now, so we can hear you.
6 p.m. Attorney Boucher for plaintiff. I do not have Attorney Fisk on the defendants.
Okay, Mr. Busher, enlighten us. What's happened with the defendants, and why don't we have an attorney present?
I'm not sure why Ms. Fisk isn't here, Your Honor. She's representing all of the defendants, and we're working, I think, pretty diligently on discovery, getting appraisal set up, and hopefully getting mediation scheduled soon.
Okay. Well, I am troubled the fact that she didn't show up.
I haven't spoken with her about this settlement conference.
Well, what we'll do is probably I will reset this about 30 days. And if you do see her in the meantime, tell her if she doesn't show up at that time, court will consider entering a default against her.
I will speak with her and find out what went awry.
Okay. Okay. Thank you.
Your
I'll
Honor.
let you go and you have a good day.
Thank you.
All right, thank you.